guess it's officially afternoon. Yes, we've started on time, so it is officially this afternoon. Thank you for joining today's Hot Talk, brought to you by the Cleveland Metropolitan Bar Association. My name is Becky Ruppert McMahon, and I'm the Chief Executive at the Bar Association. I want to say thank you for tuning in again. We are almost 50 days into this new normal that has been the COVID crisis. And like many of you, the CMBA had to completely shift course at the beginning of March. We are bringing this program to you both through Zoom and Facebook Live, which 50 days ago we were not doing. So innovation happens when times of crisis come. For sure, there have been a lot of difficulties and a lot of bumps along the way, but we have been learning as we go, and we are delighted to continue to have the opportunity to get our community connected to real information from the folks who are making real-time decisions. Today's conversation changed a little bit in the last 24 hours. Last week, we sent out our first notice of this program, and our conversation was supposed to be focused on the jail, the Cuyahoga County Jail, and a combination of the incredible job that it's been doing to reduce the headcount and the population inside the jail. And then to also continue the conversation with respect to processes and procedures that are in play right now. You saw in our original announcement that we had not only Judge Brendan Sheehan, whose great idea it was to start this conversation, but we also had some representatives from the county administration that were planning on joining us. Unfortunately, they changed their minds, and so we do not have a representative from the county administration. So I want to offer particular thanks to Judge Michelle Earley, to Jennifer Himmelein, and to Mark Wachter, who jumped in very quickly when we had to retool this conversation. So thank you in advance. We will be talking about the jail, and we will be talking about the intersection that the courts have with what's happening with the jail. But we will also be broadening our conversation into other topics. So let me just remind you, if you're joining us on Zoom, you can use the Q&A feature to type your question up and send it, and we will share that with the panelists. If you're joining us on Facebook, you are welcome to post questions directly on Facebook, and we will be monitoring that as well. Your third choice for how to get questions asked is you can send me an email directly. I will be monitoring through the program today. My email address is rmcmahon, that's MCMAHON, rmcmahon @clemetrobar.org. So with that, I'm going to stop with the introductory remarks and get us started here with this incredible panel that we've assembled. I will introduce them one at a time, but we're going to start first with Judge Brendan Sheehan. Judge Sheehan, welcome to the Hot Talk today.
Thanks, Becky, and thank the bar for putting this together. Thank you.
Well, as you know, Judge Sheehan, we are delighted to be here and appreciate your continued leadership. Judge Sheehan, for those that don't know, is the administrative and presiding judge of the Cuyahoga County Court of Common Pleas. He assumed that role just this year in January, but he has been on the Common Pleas bench since 2009. Prior to getting on the bench, Judge Sheehan was an assistant county prosecutor where he had a long and distinguished career, including serving as a member of the Major Trial Unit, as the director of the Ohio Internet Crimes Against Children's Task Force, and as chairman of the legal committee for the National Internet Crimes Against Children Task Force. Before he became a prosecutor, he was in private practice with the law firm Brown and Margolius, and before that, he was learning what it was like to be a judge by serving as a law clerk to then Judge Donald C. Nugent, who was both a state court judge as well as a federal judge. So again, Judge Sheehan, thank you for being here. I'm going to start you off with an opening question, which is, so tell us what's happening at the Court of Common Pleas today. Are you open for business? And is it, I know that you're open, but what business are you hearing today at the court?
Well, thanks, Becky, again. And I want to say hello to all your viewers. I tell you, who would have thought 60 days ago we'd be sitting here doing Zoom? I didn't even know what Zoom was 60 days ago until we started doing our meetings with the bar. I have to tell you, the court is open. We are focusing on cases that involve the jail, individuals who are incarcerated, and dealing with emergency motions, such as TROs, preliminary injunction hearings. We're also doing civil cases by video and telephone conversations, as well as a number of criminal cases. We're dealing with pretrials all by phone, and we're actually even using now Zoom for pleas. Believe it or not, we have the defendant in the jail, the lawyer in their office, the prosecutor in their office, and we're sitting in the court doing Zoom on big Mondo pads. So we're operating, and we're trying to, obviously doing essential businesses. When we, in March 11th, when we started looking at this issue, we went to a reduced docket, meaning we had 3 judges coming in the building because we wanted to keep social distancing in play. We didn't want people flooding into the buildings and obviously on the elevators in the Justice Center. So the judges all have reduced their dockets, and we're hearing those emergency motions. Matter of fact, last week, I just had a hearing on a TRO that was filed by the Board of Health on a business that was opened in Parma Heights that were not practicing social distance. And we had a hearing by phone, had the hearing, the TRO, and we also had the preliminary injunction hearing yesterday on that matter. So we're doing business, obviously in a different way, but we're doing business, and we're here to serve the people of Cuyahoga County.
Great, thanks, Judge Sheehan. So let me now introduce another member of our panel today. Judge Michelle Earley is joining us from the Municipal Court, where she is the administrative and presiding judge. Welcome, Judge Earley.
Good afternoon.
Thank you for being here. Again, for those who don't know, Judge Earley was appointed to the Cleveland Municipal Court in 2009, the same year, coincidentally, that Judge Sheehan was appointed to the Common Pleas bench. She was elected then the following November after her appointment. In December of 2017, following a unanimous vote of her peers on the bench, she became the administrative and presiding judge. So she has responsibility for the business and overall direction of the court. Judge Earley earned a BS in business administration with a concentration in information systems, which I find fascinating for a judge to come with that much technical know-how. She then decided, and that came from The Ohio State University, go Bucks, I have to put that plug in, I know it's shameless. Judge Earley then moved to Cleveland, where she attended Case Western Reserve University School of Law. And of course, we were delighted that she decided to settle her practice here in the greater Cleveland area. Since 2010, Judge Earley has presided over the dedicated domestic violence docket. She currently presides over the high-risk docket there within the domestic violence universe, and she also serves on a variety of commissions and task forces, including the Commission on the Rules of Superintendents, the Ohio Supreme Court's Grand Jury Task Force, and the Case Western Reserve School of Law Diversity Committee. So Judge Earley, again, welcome, and let me tee up the same question to you that I started with Judge Sheehan is, I know your court is open. Can you talk to us about how the municipal court is in business today?
Yes, so thank you, and I appreciate you having me here, and I'd like to welcome all the people who are here viewing with us today. We also decided that pretty much in short order that reduced dockets were necessary, considering the volume that we typically have in Cleveland Municipal Court from the onset of when the governor was talking about reducing the sizes of the number of people who could be in any certain space. You know, we immediately realized that that was not going to be something that we're going to do easily in the Cleveland Municipal Court. So we started off with just doing the jail dockets pretty early on. We have continued that trend, but not only that, we were having initially the judges were doing their own jail docket, and then we went to a process that was pretty similar to the Common Pleas Court with the reduced docket, so that there was an assigned judge who volunteered to hear all of the jail cases, and we were not having anyone come into the building, and primarily, obviously, to minimize the exposure to the public and also to the staff who were coming into the court. We are, in addition to the arraignment docket is typically what we're doing, the arraignment docket and the jail docket. We're doing those via video conferencing. So we have created a process to where we are not in the courtroom with the person who's in jail. We're actually have a process set up to where we could do video conferencing with them. and still hear those cases. We're still doing our jail dockets 6 days a week, Monday through Saturday, to make sure that the cases are processed in a timely fashion, taking into account the fact that the situation we're in is very serious, but also taking into account the people who are in jail also need for us to handle their business in a timely fashion. So we're still doing that. We also are, as a common pleas court, doing emergency matters, and that's protection orders. We're also doing release of vehicles, driving privileges. We have a very limited number of people who are present in the courtrooms regarding our staff. And we have, if there's someone who has driving privileges to their assigned court, that person can call and leave a message with their judge, but they can also contact my office, and we're making sure that those things are handled, so that if there are some things that need emergency attention, we're doing that as well. And we're kind of working with the common pleas court to figure out kind of what's going to be the new normal. This is one of my first, I guess it's one of my first professional Zoom meetings. I know my last call, when my municipal group got together, we were the love club. So we didn't, with all my technology background, I didn't wing that one too well. So, we're kind of getting used to this new normal, and hoping that we can make sure that we're still administering justice, but keeping people safe as well.
Absolutely. Thank you. So let me ask you a question. We both talked about the jail. 45 plus days ago, the population at the jail was hovering around 2,000 individuals. It is now, last I heard, under 1,000, which is truly remarkable. So I'm wondering if you can talk about, and recognizing we don't have the folks from inside the county here, but from your perspective, the bench, what made this incredible move from about 2,000 to, as I said, under 1,000 possible? How did that happen?
Thanks, Becky. I'm going to say this wasn't one individual. This was a team effort. It was a team effort by the public defender, the local bar. It was a team effort by all the common pleas judges. It was a team effort by the sheriff. It was a team effort by Cleveland Municipal Court, and definitely the suburban courts, because we looked at this bill. We looked at this, and the county prosecutor. I hope I didn't forget the county prosecutor. We started this whole process. If I can give you a little history, on March the 10th, I was concerned with news reports, what was going on with this COVID-19 and what's going to happen. And I thought, I talked to Dr. Bruner from the jail and said, if this hits our jail, what would happen? She immediately said to me, Judge, if this hits our jail, it's going to paralyze our criminal justice system. And it's not a matter of if it hits our jail, it's when it hits our jail. And with that being said, I said on the next day, I said, we have a judges meeting. Doctor, would you mind coming to our judges meeting to talk to everyone about what you anticipate would happen? She did that, and Dr. Bruner did a great job explaining it to all the judges. And so we looked at our situation and said, all right, guys, we have, at the time, I'll tell you the exact number, 1,978 people in our jail. How are we going to reduce this number to a manageable number, so the jail, when this virus hits, can quarantine and move people around and not be dealing with an overcrowded jail? Well, in fairness to all the judges, every one of our judges, if you think about it, we reduced over 3/4 of our jobs, and we focused solely, we weren't dealing with trials, we weren't dealing with civil cases, we weren't dealing with meetings. We had everyone working on the jail, and we had every decision maker present in the court. And what do I mean by that? We had the prosecutor talking to the victim. We had the defense bar sitting there with their client. We had the supervisor who marks the case present in that court. Everyone, we took a time frame that was this long and shrunk it to this short of a time frame. So we were able to get decisions made on cases and protecting, remember, we're protecting the defendant's constitutional rights and the protection of the public. And that was a big concern for all the judges. We're protecting both the public and the safety of the inmates in that jail. And all the judges agreed. We did these plea days. We not only did it, we did it Monday through Saturday. We were able, and with the help of all the courts, not just the common police courts, the Cleveland Muni courts, the suburban courts, everyone was willing to look at their cases, their jail sentences, and we were able to move cases through to, I'm proud to say that number as of today was under 1,000 inmates. So from 1,978 to now less than 979 defendants in that jail. We have prepared the jail and prepared the county for a disaster that could have hit and caused, which around the country, we became a leading role model to all these other prison and jails. They're like, how did you guys do this? And it was the sheriff. Didn't take in low-level felonies, which was a big thing. So we were cutting down the low-level entrance into that jail, and we were able to reduce those jail numbers to, I feel, that we've done some good things, and we were able to get that down. Just so you know, that virus did hit our jail. And as of today, we have 30 inmates that are positive for this virus. And they are being treated they're in great shape. They're being treated, they're quarantined. The population has been quarantined, and the jail is being able to manage these numbers now because of the work that all of us, and not me, not just the common police judges, but everyone in our system working together, we're able to reduce those numbers. So that's where we're at today. But I'm telling you, every day is a new dilemma, because we're on conference calls with all the stakeholders, because the prisons now have inmates that are all positive for the coronavirus. We all heard of the news reports about Marion being shut down. The Department of Corrections are limiting the ability for us now to send people to the prisons. So we put ourselves in a position that we're not just opening the courthouse and the jail and saying, go out, be done. We're protecting the public and protecting the community, and we're doing it in I think a fair, reasonable way to make everyone feel comfortable about how the courts are operating now. So that's a long history about what we've done since March 11th, and thanks to every teamwork, we're able to do this.
Judge Earley, anything you'd like to add from your perspective?
Just on behalf of the Cleveland Municipal Court judges, we were able to kind of just continue what we had already started with our bond reform and pretrial services. So, we were already taking a very close look at who we were sending to the county jail because of some of the issues that were in the jail in the past. So we had already had a conversation amongst ourselves about the use, or basically the use of the jail as a tool for sentencing, and kind of minimizing that as a collective group is kind of what we were already kind of focused on doing. And we had probably prior to this reduced our population of what we would normally have in the county jail to 50% with the use of our pretrial services department, which was a significant increase in what we're kind of able to do pre-detention. We ramped it up a notch in terms of reducing our numbers, and then even the people who may have had, for instance, the driving under the influence, something where the sentence is mandatory, we did not. We stayed those sentences. So, we kind of did a collective effort to say, this is important, and we were low before, and we just kind of kicked it up a notch to make sure that we were not jeopardizing the safety of the community, because we do have a number of people who are involved in the pretrial services that we're still offering while during this time, monitoring and keeping in contact with people to make sure that they're not, endangering themselves or putting the community at danger. But we just, really have decided that in terms of the safety of the people that we're servicing, that we were going to greatly reduce our use of the county jail. So.
Thank you. So Judge Sheehan, I'm going to ask you one more question before I bring in our other panelists. And this is a question that is pouring in from lots of different places right now, which is, so Judge Earley described on the one hand that the municipal court had lots of different pretrial services and bail and bond reform efforts that they've been undertaking for the last couple of years that helped sort of deal with the crisis when it hit. They were sort of in motion. What we saw your court in collaboration with others do was to really build new process, new ways of talking to each other and getting people through the system. Are you anticipating that this new and improved, more efficient system is something that will continue post-crisis so that we endeavor to keep the jail population a long way away from that 2,000 number going forward?
You know, Becky, I've been asked that question probably 1,000 times, and I hope, I really do. I will tell you, Judge Earley and I have known each other for a long time, and we worked together when we were both prosecutors, and it's a pleasure working with her now. We are in the process of, there's a lot of good things that we've learned during these last 60 days. There's a lot of things that we were doing wrong. There's a lot of things we're learning about our processes. And I'm hoping, I really am, that after all this is over, when this is done, that we can take all the good things that we learned and implement it so we can keep this jail population down, because it is so much we are looking at. I mean, with the help of the prosecutors doing these plea days, jail concentration days, whatever it is, we're doing something that is making the jail population reduced. And I'm hoping, and I really am, because it's a team meeting, I'm hoping that we get everything together that we can keep doing this. And, you know, one of the things that we have, the court has been working on court supervised release and GPSs. And between the communications between all the stakeholders, I hope that's been the key to our success, communication and teamwork with everybody. It's not the court doing this with not the help of the bar, the defense bar, or the prosecutor. Everyone's working together. And I'm hoping that's something we can continue. And I think, I really am hopeful that it will keep the numbers down. So thanks.
Great. All right, so at this point, and we are going to take questions. I just answered, I asked one question that really represented about 4 different submissions that I've got. We're going to talk another 10 minutes, and then we'll turn exclusively to answering questions. Judge Sheehan, one of the things that you did pretty quickly in this was about a month ago, recognized that you were hearing feedback from some practitioners, lawyers who were having challenges working their way through various divisions of your court. And so you convened a bench bar task force. I'm wondering if you could talk a little bit sort of about that task force, and then I'm going to introduce our 2 other panelists.
Absolutely. You know, in fairness, Becky, when we were getting these jail numbers down and all these things, we're focusing on the jail cases. I was getting a lot of calls and feedback from the civil bar saying, you know what, there's a lot going on here. Our firms aren't able to make payroll. There's people we're laying off. There's different things. We're not able to get hearings because the court's not hearing our civil cases, because a lot of judges just suspended the civil docket till this gets back to normal, they thought. And I thought, oh my goodness, we need to, I reached out to the bar, and I want to thank Ian Friedman and you, Becky, for helping me. I said, we need to get a think tank together with the bar and talk about what we can do, just like we did with the jail, what we can do with the bar that we can implement to our judges and get the not just me, meaning the common pleas court, but we're talking about juvenile court, probate court, domestic relations court, and get these courts all together in a conference call so they can hear from the bar saying, hey, here's our needs, here's our issues, we need help. And we did that with the help of the Bar Association. And just so you know, we formed working groups. We had a civil working group, a Court of Appeals working group, a criminal working group, a domestic relations working group, foreclosure housing court working group, juvenile court working group, municipal court working group, I think we call that the love group, Judge Earley, municipal court working group. And we put those folks together, and we meet every Wednesday, and we've been going on for, I think this is our 4th week of doing this. It has been so, I mean, the things that I've heard, just to give an example to your audience, I mean, there were firms that were saying, we're having a hard time getting our fees approved. Is there anything you can do? And we got, with Judge Russo responded quickly to that in probate court. And he said, okay, we're going to move on those and get things moving. So it's been very positive feedback. We've been listening, and we've been hearing the bar's issues and bringing it back to our benches and saying, how can we improve and what we can do to make things better for the civil bar. So with that being said, that was, thanks to the bar, we were able to get this listening group together. I call it a think tank, because it really has been some great responses for the courts to respond to, and how we can respond. And I'd love to hear more comments from everyone on that. So thanks.
Great, thank you. And so one of the examples of those task forces that you mentioned is the Domestic Relations Task Force. It's being chaired by Jennifer Himmelein, who is a partner with a law firm of Cavitch, Familo, and Durkin. Jennifer joined the firm as a litigation paralegal in 2004, and then worked her way through law school and became an attorney with the firm in 2009. So the same year that Judge Earley and Judge Sheehan joined the bench, Jennifer joined Cavitch. Jennifer focuses her practice on family law, including domestic relations, juvenile, probate, and mediation. She represents a variety of clients in the domestic relations court across the full spectrum. And she's a graduate of the Cleveland Marshall College of Law with an undergrad to Kent State. Jennifer, I'd love to jump in real quickly, short on the bio, high on substance, and say, so tell us about your working group, and tell us what you can say, tell us in terms of how the domestic relations court is working in this COVID environment.
Sure. Thanks, Becky, for having me here. So the Domestic Relations Working Group is comprised of our administrative judge, who is Judge Leslie Celebrezzi, myself, and attorney Susan Stefanoff. We also recently added Magistrate Serpi Ergen and Alexandria Rudin from Legal Aid. So we've been, actually from the get-go, been meeting regularly each week to talk about issues that face our particular court. And like the judges have already mentioned, the Domestic Relations Court is still open for business. They're hearing domestic violence cases and emergency motions. And they're pretty quickly, the judge seamlessly transitioned us into having telephone hearings for our pre-trials and our statuses and settlement conferences, as well as moving our uncontested divorce hearings and dissolution hearings to Zoom. Our mediation department at our court has been great. They have now transitioned to Zoom as well, so we're able to have our mediations getting heard, and we're talking about avenues that we can explore to have more cases pushed either to the court's mediation department or using volunteer attorneys to have mediations to move some of these cases along. But we've been able to sort of continue on business as usual under our new normal and have our cases be addressed and our litigants be heard. So I think that's been an important thing, and really it's the credit to Judge Celebrezzi and the court to making all this happen very quickly. We brought to the judge pretty much right away. One of the overwhelming things that we were hearing as practitioners were parenting time disputes. Some parents didn't want to send their children for, if the other parent was a first responder, or they didn't believe that parent was engaging in the appropriate social distancing and things like that. So there were a lot of people very confused about how to address parenting time issues amongst, during this time. And so Judge Celebrezzi quickly issued an administrative order to help us, wrangle in that issue. There's been a lot of questions coming from our bar in terms of handling support issues and things like that. So the judges and magistrates there have been really great in keeping things moving along and helping us address the issues that we're hearing from our clients and from the litigants of our court.
Great, Jennifer, thank you. So what are you hearing in terms of, I know that you've got a full practice, what are some of the common issues that are hitting your plate with greater frequency in the last 45 days since the COVID shutdown occurred?
By far for me, anyway, I do a lot of guardian ad litem and parenting coordination work. So I'm working with high conflict families. So a lot of people have been having issues with parenting time orders and how to address those, especially with school not being in session, and how are those orders being interpreted. So we've been hearing a lot about that issue, as well as people who are not working right now, and how are support orders being addressed. So that's been a big concern that's been coming up for my clients, and the court is addressing those on a case-by-case basis, depending on the industry that the person is in, and things like that. Another thing that's come up a lot recently is with the stimulus check that's come out, which parent is going to get that and how is that going to work? So that's been another issue that's on sort of the radar for the court. And then I think overall, families are in distress, and financial issues typically breed more divorces and more domestic violence, unfortunately. So we have been seeing, I think, at least for myself and others that I've talked to, we've been seeing an uptick of, people who are having, some family problems and some domestic violence and divorce issues. So I think, people who might have been sort of teetering on the edge of whether they were going to file, this has sort of pushed them over the edge. So I think those have been the biggest things that we've been noticing from our practice area during this time.
Great. And I just got 2 messages from people asking, they're having exactly some of the issues that you've described, Jennifer, and they're asking for how they can get help. So let me just remind those that are viewing us, the Cleveland Metropolitan Bar Association runs a lawyer referral service, which is free, in terms of getting you connected to an experienced practitioner who could help. If you don't already have legal counsel and you're looking for some guidance about where you might go, feel free to jump on our website, which is clemetrobar.org. We'll post this also on Facebook, but you can get directly to the lawyer referral service and get connected with attorneys like Jennifer and others. And I'm sure Jennifer would be able to hear from you as well. Jennifer, what's a good email address for you?
J, and then my last name, HIMMELEIN at Cavitch, which is CAV as in Victor, ITCH.com.
Great, terrific. So Jennifer, at this point, I'm going to shift over to one of your colleagues. Joining us from one of the other working groups that Judge Sheehan mentioned is Mark Wachter. Mark is a member of the Civil Litigation Working Group that has been taking a deep dive in all things litigation related. Mark, in his day job, is with the law firm of, oh my gosh, Mark, I just lost your firm's name, Wachter and?
Wachter Kurant.
Kurant, of course, with a K, Kurant with a K, forgive me. And Mark has been practicing there with his firm and his colleagues, where they focus on business, real estate, construction, and commercial dispute resolution. Mark is really one of the most recognized in our local community members of the alternative dispute resolution arena. He is currently chair of the Cleveland Metropolitan Bar Association's alternative dispute resolution section, where we are delighted to engage him in a variety of different capacities. When we put the call out because of this task force that we were thinking about helping add to the court's services on mediation, Mark was very quick to jump in. So Mark, maybe you could talk to us a little bit about the discussions that are happening inside your work group relative to the concept of a mediation day and supplementing what the court already does.
Sure. Thanks very much. I noticed that you failed to mention that I graduated from the University of Michigan. It's okay. I mean, if you couldn't find
I didn't forget. I will admit completely it was intentional. As a born and bred Buckeye, I just have to ignore that happened, and I still like you, Mark.
All right. Let me shift to what we've been doing in the task force. There's really 2 aspects. Andy Goldwasser heads up the civil task force generally, and talking about moving cases forward on the civil side. We all recognize that as this starts to unwind and we start to move back to what we used to consider normal, that there's going to be some backlog. There's going to be some time before the civil bar is able to have cases heard, and that's kind of be expected. So in response to that, what Judge Sheehan and some of the others on the task force suggested was to put together a very aggressive mediation program to start to, as I said, clear out the river before the log jam starts, to start to take some of the cases that some of the judges may have, refer them to mediation, and perhaps get some of these cases resolved now rather than wait until things sort of turn back to what we used to consider normal. So what we've done is put together a sub-task force, if you will, of Mike Unger, Joe Mumford, and Joe Morford, and me, to try to put this program together. What we hope to do is to get a group of really top mediators together, have them available for a mediation day, which right now we've set for the second Friday of each month. Kind of an artificial date, but it's out there for the court and the bar to be aware of, and refer cases to those mediators who will be acting on a volunteer basis. They're going to volunteer at least 4 hours to mediation each month from now and through December, understanding that there's going to be more time involved. It'll probably be more like 8 hours of actual work time to try and take on some of these cases, get them cleared out right away. To give you an idea of what the response is like, I sent out a sort of call to arms yesterday to the ADR section asking for interested mediators, hoping to get a group of about 25 really qualified mediators together. As of last count last night, I had 27. I think we're up to about 40 right now, and all ready to go, from top mediators, retired judges, law school professor, AAA staff, assistants to some of the judges, some really top, very strong mediators who are going to be able to step up and help work on these cases. The way it will work, we hope, is that judges, staff attorneys, working in conjunction with the current ADR department and Rebecca Wetzel, will refer cases to her. She'll act as sort of the gatekeeper and provide a panel of appropriate mediators to the parties or to counsel so that they can select a mediator who will start working on the case right away. And again, we hope to do this each month, right now, from now through December. And with that number of mediators and some kind of a good success rate, we really hope to be able to knock out some of these cases. The other aspect to the mediation program is that before things started to wind down, Rebecca Wetzel in the ADR department had a backlog of about 80 cases that were ready to be heard on the regular mediation day. Those are typically cases that are a bit smaller, either in dollar amount, simple issues, small collection cases, and there'll be a day every 6 months or so where attorneys will volunteer to try to work on those cases, usually 3 or 4 cases a day. And so we're going to take some of the mediators who have volunteered to work on this mediation project and refer them to that part of it, hopefully being able to take on quite a few more of those cases and get some of those knocked out as well. So that's the mediation program kind of in a nutshell. It will operate much the way a typical mediation does. You'll expect to hear from the mediator. You'll expect to have a mediation statement to the mediator, whatever that mediator's preference might be. Of course, the big difference is that all the mediations will be handled by Zoom or some other kind of platform. And all the mediators, in order to be able to qualify for this, will have to be instructed or show some proficiency in being able to use Zoom or one of the other platforms. Some of you who are familiar with it know that you can actually have breakout rooms in Zoom, conference rooms where the parties can meet the same way they would in a typical mediation caucus. And we've been using it very, very successfully so far. Hope to get the whole panel up to speed on it and start working on these right away. So that's the mediation program.
Great, thank you, Mark. Thank you. And Mark, if anybody is watching us and is interested in connecting with you to either learn more or to volunteer their services, how can they reach you? What's a good email address for you? Right,
yeah. My email address, mwachter, so my first initial, WACHTER, @ LAWKKWT.com, lawkkwt.com.
Great. And thank you to Wachter Kurant for sharing your time. And again, my apologies. I had your email address listed down. And so the Kurant went straight on my head, but I won't forget it again.
Not a problem.
So listen, so let me dive in now to questions. We've been getting lots of or additional questions. Judge Earley, let me come to you, and then Judge Sheehan. A couple of questions have come in. Everyone is talking about Zoom and other video conferencing capabilities. And there are a number of questions about, do either of your courts and do either of you as the presiding judges in your respective courts have any concerns about the use of Zoom and other video conferencing software in taking pleas and having communications with defendants, et cetera, any concerns about the constitutionality of using video conferencing?
So we haven't utilized Zoom for pleas. I think just the common pleas court is doing that. We have the video conferencing that we currently use, that we have been using for the individuals in our court, that we actually do take pleas via video conferencing. And we have utilized video conferencing probably since I was a judge on the Cleveland Municipal Court because of the transportation of individuals. And that defendant is typically in the courtroom via video conferencing, and it's real time with the attorneys in the courtroom with the judge. We have not had any issues or challenges regarding that currently. In addition to that, we had a process set up where the defense lawyer could have a private conversation with the individual prior to coming into court and taking that plea or having that hearing on the record. So we had not been transporting individuals back and forth to the actual courtroom for Cleveland Municipal Court unless it was a trial, just for the safety of the individuals who are being transported and for the safety of the staff. So that's a process that we put in place when we were utilizing the Cleveland House of Correction, and we kept that in place. So we had video conferencing capabilities in all of our courtrooms with the exception of maybe 2 of them. And I think we're now kind of just doing it a little bit more advanced in terms of the arraignment room. We were not doing those via video. We were doing those in person, and we're doing arraignment videos currently. So that's kind of the process that we've always taken with a real-time type of plea hearing and I believe that the Constitution allows us to do that.
Great. Thank you. Judge Sheehan?
Yeah, Becky, I love technology, and I love Zoom. And man, we were talking about virtual trials back in the day, like 4 or 5 years ago, and everyone's like, no way would anyone ever do this. And here we are. This put us in a different world now, and all of a sudden everyone's talking about doing virtual trials and how do we use Zoom. But I have to tell you, we have been, the prosecutor and the public defender have been very concerned about using Zoom in terms of pleas and plea colloquies and how we do it. So before we accept a plea using Zoom, we have obviously made sure that the defendant waives his right to be present in the court. We get a waiver. Everybody is all in agreement before we use the Zoom capabilities to do a plea. But what is really the interesting question, and what we're struggling with, is, let's say, because of social distancing, a judge wants to use Zoom. They're in their house. The prosecutor is in their house or their office. The public defender is in their home or their office, and the defendant is in the jail. Does that constitute an open court? Is that an open court proceeding? And both the prosecutor and the public defender have provided me with memos and law that says, Judge, we don't believe that is a fair or a open court process. And then I respond back, because I love Zoom now and I've done all my research on it. I'm like, well, wait a minute, just like the bar's doing right here, we post it to YouTube. Isn't that an open proceeding, open to the public? And isn't that availability, and it's an open proceeding? Their concern is that it may not be because it's not in the courthouse. And so we're struggling with the issue. We're thinking about it. We're looking at all the different angles and legal analysis of it. But for now, I can tell everyone, as far as I'm standing here today with you, we are doing pleas in the courtroom, in open court, with a court reporter present, and the public defender or the defense lawyer and the defendant and the prosecutor are being Zoomed with a waiver from the defendant. So I don't know if that's a long-winded explanation, but that's where we stand as of today. I think as we move forward with these next issues, I mean, we're even talking about doing trials via Zoom on the civil side. So, we're out there, we're rolling, we're trying to use technology to our advantage so we can provide everyone their access to justice.
And then, I'm sorry, we are not utilizing Zoom for any of those capabilities. We're just further utilizing the video conferencing that we currently have. And then the discussion that the attorney is having with the client is a point-to-point contact with the jail from a setup that we have in the court. So we have not expanded that, but we are obviously looking at different types of options to minimize the number of people who have to come downtown as well. But we are not utilizing Zoom for that at this point.
So let's topic a little bit, and so because we're getting lots of questions about, so whether it's video conferencing, whether it's Zoom, whatever the tool is that you're using, how are you ensuring confidential communications? You said point to point, Judge Earley, in terms of conversations between lawyers and defendants who are sitting in the jail. How are defendants getting documents? How are they signing documents? If there's a waiver to be signed, how are they getting access to that? And if there is need real time during one of your proceedings for a defendant to consult with a counsel, how is that happening? I hear somebody said they hear the preparation in advance or the opportunity to talk with lawyers in advance, but what about real time? How is that process being managed?
So, and how we have done it in the past in Cleveland Municipal Court is if there is a individual who needs to have a conversation with their attorney, we typically, because we do have a separate private room for the lawyer to go back and talk to the individual, so we will allow them to do that and then get back on the video conferencing when they're done. Typically, and this probably will not be the case when we come back to running full speed, but typically there are a number of other matters that the court is handling, and the court will do some other people who are currently in the court who are not in jail, and will handle those proceedings while the attorney has a communication with their client while the client is in the county jail in that private room that we have set up on each floor that has video conferencing.
Becky, if I can jump in our test runs with Zoom, we had a representative of the public defender, representative of the prosecutor, myself, and all the technology folks together. We actually, as Mark mentioned, is with the mediations, we've used those private rooms in Zoom. So for example, if you're doing a plea colloquy using Zoom and the defendant has a question regarding an issue and during the plea colloquy, we have set up in the Zoom process, Zoom rooms where there's private rooms where the defense lawyer and the defendant could be in with outside everyone else in the court there, me, the prosecutor, the court reporter, everyone's outside of it. Those folks have that private conversation in the Zoom chat room. And then when they're done and they resolve that issue, they come back into the Zoom room where everyone's at, the courtroom, and they continue on with the plea or the conversation that was going on in the court. We've been using these technology and practicing it with the COs in the jail to make sure that everyone has the protocols in place. And we've seen with great success and confidence from the public defender and the prosecutor that they think this is a great way to do it. So we're using technology in those chat rooms, just like the mediation is doing in those private chats, to do this possibility of using Zoom for pleas on our side.
Okay, thank you. So related questions, we're talking a lot about folks inside the jail. Two questions. One is, are you aware of whether or not the jail is permitting lawyers to do in-person meetings, visits with their clients currently? And secondarily, there is some question about how lawyers are getting access to the jails to schedule video opportunities. Even if they can't get there in person, there seems to be some confusion about the process in order to get connected to a client who is sitting in jail. Do you have insights on either of those?
Yeah, I mean, I can't speak for the jail, but I will say that if the listeners go out and they go to the jail website, they have used a video conferencing so they can have access to their client using the Securus system, which is in place. And this Securus system allows the lawyer to have, and we're working on a private conversation with their client via video conferencing. And we're the jail I know is setting up rooms and trying to set up rooms so the lawyer can have private conversations via video with their client. Now, as for face-to-face visits, I don't know. I don't know how the jail's handling that. I would tell you this, I do ask in our daily meetings with the jail folks, how does one know, how do they do this? And they have said that I guess the public defender is discouraging their lawyers from going over face-to-face. So I don't know how the jail is handling the private lawyer going to see face-to-face or not. So I can't answer that.
All right, let me ask another question. We've gotten a series related to questions regarding judicial releases, and I'll paraphrase a couple of them. Is there any current protocol or planned protocol to create a unified practice as relates to judicial releases? Apparently, some judges are timely in replying, some don't reply at all. Some are requiring in-person appearances and some don't. Is there a way to simplify this and or to get on a same or similar track across courts?
Yeah, that's a great question. I will tell you that the public defender has talked to me on that issue, and he has filed, I think, or about to file 180, 190 judicial release motions in our court. And I have, obviously, the procedure that we have, Judge Nancy Russo has done a good job running our reentry court, which she has done a review of those packets. And we went over with the public defender on the reentry court criteria. And she and the public defender have worked on that criteria. And I think the private bar understands how that reentry court works, that criteria. But what is uniform, and what I can guarantee this, is that each judge has an opportunity and does have an opportunity to review those judicial release motions. But if that judge is willing to entertain that judicial release motion and wants to have a hearing, well, obviously with what's going on in our jail and what's going on in the prison institution, we can't bring back those individuals. So we have worked out a system with the institutions that we are able to use, again, technology. We're able to put the defendant using on video, the court being on video, and the defense lawyers being here on video. And we have worked out that there is at least that protocol in place, that if that judge is willing to entertain a judicial release motion, if that judge is feeling comfortable with wanting to do that, we have set up a system, and it's being used today. We had 6 hearings, judicial release hearings, by our judges today on judicial release motions, all from the institution, where we didn't have the expense of bringing back that person, but we have absolutely been able to have that hearing via video, and we're able to get those hearings moving forward. And the prisons appreciate it because they're wanting to release people out of the prisons, and the court is able to expedite it. Now, on the judges who are not having hearings, on the judges who aren't entertaining those judicial release motions, I have had defense counsel who call me and say, I have a case in front of Judge so-and-so. I filed this motion, we're not getting a response. And what I do then is I call that judge. I quickly, obviously with the reduced judging, I quickly advise the judge, hey, this is on your docket. How do you want to handle it? So if your clients if you filed a motion for judicial release, you're not getting any feedback or hearing back, call me. I'll quickly call that judge. And there may be reasons for that. Some judges aren't entertaining it. Other judges didn't realize and are moving quickly once they get notice of it. So again, we're trying to do everything to expedite these hearings, so there is some protocol in place. So we're not just, they're not sitting in limbo.
Okay, next is a series of questions. We have several around the constitutional and statutory rights to speedy trial. How will the delay in criminal cases relative to defendants who are not in jail be impacted?
That's a great question. The Chief Justice has issued a tolling order that would allow the suspension of speedy trial rights until July. And, you know, we have not, and that's part of our rollout process come May 11th, as we plan on how do we open up the justice system after our reduced judging is in place. And we don't plan on just saying, okay, here we go, we're open for business, bring in these cases, let's try them. We are planning and Judge Earley and I are meeting on Friday on this topic. We're talking about a slow rollout and how are we going to handle those bail cases, and how are we going to keep social distancing in place, and how are we going to handle these trials. And we are documenting, we are planning to play a rollout, and I know with the bench bar committee, we're also working on that. The members of different committees are on this case flow committee that I have tasked Judge Russo with. So we're working on it. We have clearly not forgetting about the bail cases and the speedy trial cases, and we're hoping to protect everybody's rights and also obviously the safety of our community.
Judge Earley, do you think it's possible that the municipal court reopens and conducts trials where social distancing, physical distancing is still in play?
So obviously, I do believe that we will be opening at some point, but not until we can make sure, well, and we actually are currently open, but I think we will be probably not doing a lot of trials until we're able to make sure that we could do them in a safe manner in terms of social distancing, until we can develop a schedule to where you know, there are not a number of people coming down into the Justice Center, you know, jeopardizing their safety or the safety of the people that need to be here. You know, we typically, there are 12 municipal court, Cleveland Municipal Court judges, in addition to the housing court judge, and that's in combination with the 34 common pleas judges and the number of other things that are in the Justice Center. So, you know, as Judge Sheehan just said, you know, it is imperative that we work together to roll out our dockets and trials, so that, you know, we're making sure that the number of people that are here is still a safe number, because, you know, the worst thing that could happen is that we rush too soon to get back. And then as a result of that, we've created a hot spot in the Justice Center to where everybody now is potentially, you know, ill because of the actions that we've done. So I think that we're both really kind of even maybe painstakingly trying to walk through this and trying to make sure that there are a number of matters that, you know, the unfortunate part, there are a number of matters that were ripe for resolution right before, you know, we had to kind of pull back. And we understand that there are a number of people who want their cases resolved, and you know, that's understandably. We're going to make sure that we're able to administer justice and get those resolutions, but also do it without jeopardizing the safety of the individuals who come before the court, the people who work with the court, and also the attorneys who are assisting in resolving those matters. So, you know, those are the things that are going to be in the forefront, and we're going to collectively do it, you know, as a collective unit. So I think that, you know, maybe Judge Sheehan will get tired of seeing me when this is over, but you know, our plan is to make sure that we're doing it as one unit, so that we can all stay safe and prevent ourselves from being in a worse situation than we would otherwise be in.
All right, we're pushing up against the 1 o'clock hour. I'm trying to get as many questions in as we can. We have several questions around what the impact in our community is with the release of all of these defendants. What about those that involve crime victims, particularly domestic violence? Do you see an impact? Do you know what's happening? And how are the courts complying with Marcy's law concerns regarding notification to victims and involvement of victims in plea deals, sentencing, et cetera?
That's a great question. And, you know, maybe I wasn't clear. When we reduced that jail population, we didn't put out 978 folks into the streets of Cleveland or Cuyahoga County. I would say half of those folks went to prison early, and the other half are on probation and community control. I believe and I trust the prosecutors, during these plea negotiations and on judicial releases, everything, are notifying victims. And the victim, you're 100% right, Marcy's Law is in play. The victim has a right to be present and a right to be heard on any of these motions for judicial release and on these plea bargain cases. And I always make a point, and I know my colleagues do, to make sure the victim representatives are on notice for this. So that is something the prosecutor has always communicated with victims for Marcy's Law. And a lot of DV cases that were heard for bail or bond releases have been placed on GPS and GPS monitoring, so they protect the victims in the community. So we didn't look at this as ignoring it. We've definitely, that's something that the courts, the prosecutors, everyone has been notifying and making sure everyone's in tune with what's going on.
Judge Earley, anything you want to add?
We are probably, out of all the departments that are working, most of our departments are probably the majority of them are working from home. So the number of people that we have here is minimal, except our pretrial services department. We have a number of individuals who are working our pretrial services because those are the people who are on electronic monitoring, and those are the individuals that we are making sure that they're not putting, you know, the alleged victim in these cases in any harm by allowing them to be out on bond. That's the conversation that we're having with people when we're putting them on electronic monitoring in the arraignment court. Our pretrial services department, and they're socially distanced, spaced out, but they're all, you know, the majority of them are here, and we're still keeping track of individuals and, you know, trying to make sure that we're looking out for the safety of the victim. And in addition to that, for the hearings that we're doing in arraignment, there is a victim advocate that is present in the courtroom so that we have that avenue covered. So we're trying to be mindful of that because, you know, obviously the thing that would be horrible for everyone is to just release someone and then they go back and create a greater harm. And that obviously puts the community at jeopardy. And we don't want to do that. Or to the extent that it's possible, we would not like to do that.
Great. So we are at 1:02, so I've already encroached 2 more minutes. I am going to ask one more final question before I let you go. And I'm sorry, Mark, that the focus here has been on the judges, understandably. Let me just say, if your question didn't get answered, please feel free to submit it directly to me at McMahon@CLE Metro Bar, and we'll work on getting responses for everyone that's outstanding. Final question is this: before the corona shutdown, and the courts obviously are not completely shut down, but before we went into essential business only, there was a whole lot of effort around the Justice Center Steering Committee, and there was a significant amount of work being devoted by not only the Steering Committee, of which both of you, your courts are represented, but also by a number of working groups. Because of the coronavirus, obviously things have been tabled. What do you know about work that is continuing to happen relative to that steering committee, if any? And what do you understand will be next steps in terms of getting that steering committee back on track?
I can tell you that I know that steering committee has been working hard on building the jail, working on a justice center, and I can tell you that I think what's going to happen. I do believe it's going to get back on track, but I think it's going to be one of the first things they do is like, wow, your jail population has reduced to this number. What lessons were learned? What lessons were things that were good that we can implement? Now, I think that would probably be the first step back on that task force, and then from there, keep moving forward. But I think right now, with all the budget crisis and all the different things going on in this county, I don't think anyone's talking about spending more money. I think they're talking about what we did right and how we can implement that first.
Judge Earley, anything you want to add?
I think I agree with Judge Sheehan that that's kind of probably going to be the focus. They've put off having obviously the big group meetings because of the social distancing aspect, but I believe that they're still going to attempt to work in the small working groups so that we can still kind of make some progress on what's happening, and then obviously focus on, you know, lessons learned in this process. And I think that in addition to what's happening with the jail population, there are a number of things that we all kind of looked at that we can do better. So, we're kind of looking at best practices and moving forward.
Great. Well, listen, let me offer my thanks. Thank you, Judge Sheehan. Thank you, Judge Earley. Thank you, Mark Wachter, for joining us. Jennifer Himmelein had another 1 o'clock appearance that she had to make elsewhere, so she jumped off already. I appreciate all of you making time. I will say there are lots more questions that are still sitting out there that are not yet answered. We've gotten a variety of different communications from people thanking us for putting on this forum and for the direct access, particularly to the judges. No offense again, Mark. But thank you to the judges for your willingness to speak with us. There were obviously lots of questions that were directed to the jail, and there were a bunch of questions I didn't ask because we do not have representatives from the county administration and those inside jail operations to answer those questions. I'm going to keep trying to get somebody from the county administration to come join this dialogue in the future and to be a resource, because clearly people are looking for information. And there's not always good information available online. So thank you. We will have additional forums. We will be posting, if you look on our website, clemetrobar.org. And if you continue to follow us on Facebook, you will get more information about what our next conversations are. And we are constantly looking for new speakers and new ideas. So please feel free to share them. Thank you again, everybody, for joining us. Stay home, stay healthy, and stay informed to the best that you're able. And thank you again to our panelists for joining us.
Thank you for having us.
Thank you.